We're here this morning on Mr. Canales' motion to transfer the case to mediation. Ms. Bakar, can you hear me?
Yes, sir.
Do you have any objection to the matter being handled through mediation?
I don't really understand what that means, but at our last court date, the judge had asked if I'd been served with the papers that William was supposed to send, and that's why he sent it over for today, and I still haven't received anything.
Okay. Mediation is a process. It's a more informal resolution process. It's not a binding process, but it's a process where the parties meet with a third party who is a trained mediator who tries to help the parties come to an agreement. And if the parties can't come to an agreement, the matter then comes back to the court for the court to decide any disputed issues. So that's what mediation is. So this proposed order would transfer the case to mediation. Do you have any objection to that process?
No, sir, I don't.
Okay. I'm going to sign the order. Mr. Canales proposes that you pay for the entire mediation. What's that based on, Mr. Canales?
I've been having my son for almost 4 years straight, and this is going to be my 4th year having him straight. I've been paying for his medical expenses, his dental expenses, his school. I've been just paying for everything, so I just feel like it would be right in that manner of order.
Okay. Is there an order of child support in the case?
No, we just got done dealing with the child support. I was on child support for about 2-3 years when I've had him this whole time. So I had to pay her about $200, but that was it. And then the case just got dropped.
Okay. I'm going to split the costs on mediation equally at this point. And part of this process will probably require an order of child support to get entered. At that point, so at this point, I'm going to divide the cost equally.
All right, that's fine.
And I'm signing the order for mediation. So that'll conclude the matter. Regarding service of any other documents, sounds like Ms. Bakar hasn't received those yet. So I guess I would just do what you can to get those to her. Her address is listed in your proposed order. And anything you send to her should include the designation legal mail, so it has a better chance of getting to her.
Yeah, I did send her everything almost a month and a half ago, and I sent what the judge told me to about a week ago. So I'm just not understanding why nothing. I didn't actually send it through legal mail. I just sent it as regular mail. So maybe that's the reason why it hasn't got sent to her.
I think adding that legal mail sometimes helps it get through. Sending mail into DOC is sometimes difficult. So if you add that designation, it's got a better chance of getting through.
Okay.
All right. That'll conclude the matter.
All right.
Oh, I guess I want to make sure that this is, in looking at the court file, it looked like there was an MSC at some point, and it seemed like perhaps the parties had reached an agreement. Are the orders that were presented by the state of Washington agreed orders?
Your Honor, we did receive some proposed final orders for the dissolution from the parents, but I did not see that they had noted it on today to finalize the dissolution. So I wanted to inquire if they still were agreeing to those orders we had received and if the court had copies of those.
I'm sorry.
I was just wondering if the court had copies of the agreed parenting plan and dissolution. The parents had sent us copies of those, but we did not see that they've noted it today to finalize the dissolution. We would not want to enter our final parenting or child support order until the parenting plan and dissolution were also being entered.
Okay. So for the parties, I don't know if you've got an agreement or where we are, but what I have in front of me today is a proposed order from the state of Washington regarding child support, but there aren't any other proposed orders that I have. So if you have an agreement as to how you're going to resolve your case, you would need to present agreed orders to the court. If you don't, then I guess we need to get back on for trial assignment so we can get the matter resolved.
We had submitted the parenting plan that we have agreed on, but we haven't filed the divorce yet.
Okay, we
But
probably,
we are in agreement. It just needs to get filed.
So Your Honor, the state would just ask as to how long the parties would need for that, and they just asked to set over the child support to that date so that we can do everything at the same time.
and I think that makes sense. So, do we have an idea of when we could get, well, you're in agreement on the parenting plan. Are you in agreement on the issues regarding the dissolution?
I think we are. I think I'd like input, but I believe we are.
How much time do you think you need to prepare orders for the dissolution and a final parenting plan?
We already submitted the final parenting plan. Do you have that one?
No, I don't.
Okay. I would say 2 weeks.
Mr. Mills, does that sound reasonable to you? 2 weeks?
Yeah, sounds fine.
Okay. So I'm going to set this to April 17th at 9 o'clock for presentation of final orders.
Thank you, Your Honor.
And does the state, well, for the clerk, will you hold on to these orders if I give them to you?
Yes.
Okay. I'm going to give the state's orders to the clerk and she'll hold them for the hearing.
Thank you, Your Honor.
Either party here.
Yes.
Oh, and I see Ms. Hart's in the waiting room. I'm just admitting her. All right, we're here today there's a motion in front of the court asking for the matter to be transferred to mediation.
Yes.
This is Ms. Hart's motion. Mr. Secney, do you have any objection to that?
I do. I have a meeting with a lawyer at the end of the month, and I was wondering if we could wait till I have a meeting.
Ms. Hart, any position on that?
The mediation to try to do it before getting attorneys, if that's possible.
Mr. Secney, when's your meeting?
April 24th.
I'm going to set this to May 1st. And we'll look at it again then. So we'll address the matter again May 1st. We'll keep the proposed order that Ms. Hart presented. I'll have the clerk hold on to that so you don't need to present another order. We'll call this again on the 1st of May. Thank you.
Thank you.
Thank you.
Are you Ms. Thomas?
Yes, Your Honor.
All right, and I don't see Mr. Thomas here.
He's in jail, Your Honor.
Okay. Any idea how long he's in jail?
He might get out tomorrow. He's been in there since February 5th.
Okay, and ma'am, who are you?
I'm Daniel Thomas's mother. He asked us to come so we could try to tell you it wasn't a no-show. He couldn't get here.
He was served, just so you guys.
No, I understand he was served. And you think he might be out as soon as tomorrow?
He has a release hearing tomorrow.
I'm sorry?
He has a release hearing tomorrow. He's with Columbia County.
Okay,
He was served in jail, so.
okay. Well, I do think there's proper service. I don't want to move forward without Mr. Thomas when he doesn't have the ability to get here. I'm going to set this to April 17th. That's 2 weeks from today at 9 o'clock. So we'll also hold on to your proposed orders.
Your Honor, may I attend? I work full time Monday through Friday. Could I attend by Zoom?
Yes, you can.
Thanks.
Were you Nicholas David?
Mr.
Uh,
I was just, I sent him a little late. I was just,
we have not called your case yet, Ms. Brody.
I'm sorry, go ahead.
Okay, so is Holly Davis present?
No, Your Honor, she told me it wasn't on the docket.
I'm sorry?
She's not here.
Okay, I'm
She
just,
told me that it wasn't.
I'm checking Zoom for that. Check. Okay, it looks like she was served on March 16th.
Your Honor,
Yes.
I have a memory problem. Can I bring my friend up? She to help me.
Well, if she's not an attorney, I don't, she's not, so no. Okay, in terms of contempt, I've reviewed the motion. Ms. Davis is not here. Could you said that she told you it was not on the docket?
Yes, sir.
When did she tell you this?
Yeah, that's not one.
Okay. I'm not sure where she got that information.
Probably so I wouldn't show.
Pardon me?
Probably so I wouldn't be here. It's a little vindictive.
I just admitted a phone number with a 352 prefix. If that person could identify
Yes, I do.
themselves. Sir, who's on the 352 number?
This is Ivan Molina.
Okay, Mr. Molina, thank you. We haven't called your case yet. We'll come back to your matter. Okay, I don't see Ms. Davis present on Zoom. I've reviewed the motion. I am going to find that claiming the child for the tax year of 2023 is amounts to contempt. There are a couple possible ways I could go here. I could require her to file an amended return this year, or I could basically give you 24 and 25.
It's that before I'm 25. Oh,
25 is your year anyway, but I could give you 24, so you would be able to claim in 24.
Well, the thing is I only worked half the year because I injured myself.
Okay.
So I won't be working. I'm not working. So
There's
the return I would have got this year.
Would you? Okay, I'm going to require her to amend her petition then, or amend her tax return.
And it clearly states in a court order that it's my year.
In your proposed order, you checked the box for restraining order. Was there a restraining order in place?
There has been, she could get quite,
Okay, so is there currently a restraining order in place?
I believe there is, yes, still,
Is that in this case?
yes.
I don't believe, in looking at the decree of dissolution, there is not a restraining order in this case.
It's a, she can't be on the property. It's a stay away order.
Okay, well, it's not in this case. It's not in your decree of dissolution.
It's separate.
So I'm not ordering that in this case. So I'm allowing the contempt to be purged if she signs the 8332 form and files an amended 2023 tax return. But it does not claim the child. So I'm signing your order. You should be able to get a copy of this order in the next couple of days from the clerk's office. That'll conclude the matter.
Thanks. You have a great day.
You too. I have a proposed temporary family law order from Mr. Tatum. I have a proposed parenting plan from Mr. Tatum. And I believe what happened at the last hearing. Well, we're on because Mr. Tatum filed a motion for temporary orders. And there was no response from Ms. Tatum, even though she's the petitioner in the case overall, where she's petitioned for dissolution. She didn't move for temporary orders. Mr. Tatum then moved for temporary orders, and at the last hearing, there was not a written response in the file from Ms. Tatum, and the court set this matter over, and I think explained the necessity for that to happen. In looking at the clerk's notes. So Ms. Tatum, have you provided any response to the motion for temporary orders?
I filed a copy of my declaration and my mother, Jana McKee's declaration that he was served with.
When did you file those?
I filed them Friday afternoon. He was served on Sunday, and then I filed the proof of service on Monday morning.
Okay. Unfortunately, those didn't make it to the court file. So I have not had a chance to review those.
Okay. Would you want to set it over until they get there?
Yeah, I do. I don't want to make a decision without considering your side of things here. So I'm going to set it over 1 week to April 10th.
Your Honor, this is Casey with the state. If we could make the request, we have a motion for temporary child support that we've set for the 24th. It may be easier for the parties if you do everything on the same day.
Okay. I think I'll do that instead. I'm going to set this matter to the 24th of April when there's already a motion regarding child support before the court, so we can address all these issues at once.
Thank you, Your Honor. And if we can just confirm with Ms. Tatum that she did receive the paperwork that we sent out.
Yes, I did, and I'm going to respond this week.
Thank you for confirming.
All right, that'll conclude this matter. We'll see the parties back on the 24th at 9 o'clock.
Thank you, Your Honor.
Thank you. Thank you, Your Honor.
So we're here to address a few things. The court previously issued a temporary restraining order we're here to address whether that should continue. Looks like there was a motion for mediation. We had service of these, and then there's the motion for a family temporary or a temporary family law order. These are Mr. Ruby's motions. Ms. Carranza, I haven't seen any response in the file.
I've yet to respond, Your Honor. I got a little frustrated, and when looking over paperwork that was served to me, my kids have been in my care since he returned them back. Hannah came back home right out a week before her birthday last year. So the end of July. Bethany came home the end of the school year last year. Both of my girls were enrolled in Kalama Elementary in my care. The only reason they're not with me is on March 13th.
Okay, wait a minute. I'm going to stop you because you need to file
I understand.
I can't address you just bringing things up kind of during the course of the hearing. So we were last here on March 13th when Ms. Carranza apparently was on Zoom and asked for a set over via chat. Apparently she'd been served the day before, ended up having some technical issues, but was able to attend the hearing. Ms. Carranza got frustrated with the process and apparently left the hearing and expressed some things during the hearing that the court didn't appreciate. So the court reissued a temporary order. So what's in front of the court today is the request for the temporary order. I don't have any response from you, Ms. Carranza. Are you going to respond to this, or
Yes,
when would you do that?
I can have it in by Friday. We've got a lot of other things going on. I have 2 other young children at home. I start school on the 8th. It's a process, and
And are the children currently with you?
the-
Oldest
Wait a
daughter is
minute.
with me. My youngest daughter is with my sister because that's where she wanted to go. And my sister lives like 6 blocks away from me. She's currently at my house right now from break. I see her all the time. But that's just where my youngest daughter chose she wanted to go because I have 6 other kids in my house and she likes being a lot of time with my sister.
I'm going to put this over for 2 weeks. I am going to I'm going to reissue the temporary restraining order, leave that in effect until the next hearing.
Your Honor, is it okay to ask what grounds for the restraining order? And if it's not able to be answered, I understand it, but I just don't understand.
Well, I'm going to refer you to the court file and the pleadings that have been filed with the court. I don't have the right form here on the bench, but I am going to extend the immediate restraining order that was signed by the court on February 13th to our next hearing on April 17th. I'm also going to appoint a guardian ad litem.
Amy Turnbull should already be on the case.
Who is the guardian ad litem?
Amy Turnbull.
And do you know how long she's been involved in the case?
The entire time.
Okay, so wait just a minute. So if Ms. Turnbull filed a report back in 2022, has she been reappointed since you filed them?
Yes, I just talked to her before our last court date. That's the one for this one.
Your Honor, I may be able to help clarify that. I'm not sure why Ms. Turnbull's not present, but that was discussed at the last hearing. The order appointing her did not have any parameters for her discharge, so she had remained appointed. And so I don't know if the issue of her payment has been addressed moving forward. So that may be why she's not here today, but she is still active on the case.
Okay, I will, the court will reach out to Ms. Turnbull and make sure that we have a current order that addresses compensation for her. And then I'll need the parties back here on April 17th at 9 o'clock. Ms. Carranza, if you don't file a response by this Friday, what's going to happen is that Mr. Ruby's request is just going to be granted because we're now at a point where we were here in mid-March and it was explained you needed to do that. If you're going to do it, you need to do it by Friday. Any questions about that?
No.
Okay. So we'll see the parties back on the 17th.
Thank you.
Your Honor,
I'll need both of you to unmute at this point.
Hello, Your Honor, I'm here.
All right, that's Mr. Molina.
Yes, sir.
All right, thank you. Ms. Brody, if you could unmute.
Okay, I'm here, Your Honor.
Oh, it looks like the prosecutors entered a notice of appearance. Mr. Molina,
What?
Mr. Molina, it looked like you had indicated you might be hiring counsel. Where is that?
Yes, Your Honor. So I did go through, I ended up having a lawyer, but I just couldn't afford the fees per hour. I went a couple times for advice, but other than that, it just started getting too expensive as the fees were $4.50 an hour.
Okay. All right, it looks like there was service on the 2nd of February of the immediate restraining order and notice, as well as Ms. Brody's declarations and exhibits. And then there was state entered a notice of appearance, and it looked like that was served by mail. So it looks like we're here today to address Ms. Brody's motion for a temporary family law order, as well as a restraining order. So, Mr. Molina, I don't see any responses from you in the file.
So I kind of, as to where I'm at is, we've already gone through this, the year of 2022, when she had tried to take Aaliyah the first time, and then she got placed in my custody. And as far as to my notice or to my knowledge, until a parenting plan was set in place, Aaliyah was supposed to remain in my custody. And she was allowed to be, her mother was allowed to come see her once a month for 4 hours. Transportation was up to her. And as far as I know, because there was never any parenting plan set in place, that my daughter should still be in my care.
Okay, well, that doesn't relieve you from needing to respond to her motions.
Okay. The only thing that I've gotten from her besides, the notice of appearance was just the allegations basically stating that she had put against me, and her file claim that she's filing now.
Well, and those are the allegations the court's dealing with here.
Okay, so how would I go about responding to those then? I have no problem responding.
Pardon me?
How would I go about responding to that, and what would I need to do?
Well, I can't give you legal advice, but you need to file pleadings in response to what she's asking for. And you need to present those to both the court and Ms. Brody.
Okay.
Ms. Hyde, are you involved in the case?
Your Honor, I was appointed guardian ad litem November of 2022. And it was a very sketchy case because to get any information from because of the housing situation and contact situation with Ms. Brody. During the time of my investigation, she was very difficult to reach, and eventually some decisions were made, and I was then discharged in June of 2023. So I think need to be reappointed probably, if that's Your Honor's thinking at this time.
All right, I think we're in the case in a similar situation to the last case. The court, I think, needs a response. We need a response from Mr. Molina, and I think it's appropriate that we reappoint Ms. Hyde, given the allegations Ms. Brody's making and the history of the case.
When I was appointed previously, Your Honor, it was appointed as a county pay case, if that's helpful
And I think that's
today.
looks to me like that's probably still appropriate. So this would be a county pay case as well.
All right.
Your Honor, if I may, I haven't seen or heard from my daughter since December 13th. Ms. Brody has blocked all communication or
Well, at this
anything.
point,
I
okay.
was just wondering.
Give me just a second, Mr. Molina.
Okay.
All right, the order that was signed on February 1st does have the child with Miss Brody until the matter is resolved. Prohibits Mr. Molina from removing the child from the state of Washington. But beyond that, does not prohibit contact with, is it Aaliyah? Aaliyah? Okay.
Yes.
It's a. If I could chime in though, the stuff that is needing to be investigated here or whatever is, and I've even submitted documents like showing my daughter's condition that she was in. It should give us the right to space from him while this is being handled, because she was not in a good state when I picked her up. She was,
and I understand that. I understand that, Brody. I understand that's your position, but the court did not issue a restraining order. What they did was they placed the child with you. They did not restrain Mr. Molina from having contact. Between now and the 17th, our next, well, I'm going to set this out 3 weeks. Mr. Molina, I need you to have a response to the court and to Ms. Brody by April 10th. That's 1 week from today.
Okay.
We're gonna address this again on the 24th.
Your Honor.
In terms of, wait a minute, in terms of, was that Ms. Hyde or Ms. Brody?
Yes, I am not available on the 24th. My apologies, Your Honor.
Are you available on the 1st of May?
I am, the 17th and the 1st, both.
I go to the 1st of May.
Thank you, Your Honor.
Between now and then, I'm going to allow visitation with Mr. Molina from Friday the 12th until Sunday the 14th, Friday at 5 until Sunday at 5, and Friday the 26th at 5 until Sunday the 28th at 5.
Okay, so does he come and visit where she's at, or do I have to let her go with him?
She goes with him. And
oh my goodness.
Mr. Molina, is it, wait a minute, Mr. Molina, I'm going to require you to do your transporting.
That's fine, Your Honor. Can I get the dates one more time, though? I got Friday the 12th at 5 and Sunday.
To Sunday the 14th at 5, and the 26th of April at 5 to the 28th of April at 5.
I'm sorry, I'm writing these down right now. I'm sorry. Okay, can one more time, Your Honor? I'm sorry.
So that's fine. April 12th at 5 p.m. to April 14th at 5 p.m. April 26th at 5 p.m. to April 28th at 5 p.m.
You're going too fast.
Wait a minute.
You're going way too fast. April.
Mr. Molina?
My Wi-Fi is bad as well.
Ms. Brody, please stop. Mr. Molina?
Yes,
I need
Your
you
Honor.
the child is not to be removed from the state of Washington.
Correct.
All right. And then this will be a county pay. And the court will, I will prepare an order reappointing Ms. Height.
Thank you, Your
Will Ms. Height need to be there or for drop off and pickup, or just Ms. Brody and I agree on a location for drop off and pickup?
Is there any issue with it, with drop off and pickup? Ms. Brody, can you agree to a location with Mr. Molina?
Yeah, I can agree on a location.
Why don't we just say you both know where the Hall of Justice is in Cowlitz County?
Yes.
Let's have the exchange at the Hall of Justice in Cowlitz County.
Okay, Hall of Justice.
You know where that is, Mr. Molina?
Okay, my Wi-Fi is very slow.
Oh, Your Honor, I
Can you get
can GPS it.
The address is 312 Southwest First.
Thank you, Your Honor.
Anything else I need to address today?
Your Honor, if I might.
Your Honor, my Wi-Fi is. I need the dates. Is all. Sorry.
Ms. Brody, I'm sorry, I didn't hear you. Try again.
Yeah, my connection's bad. Dates are saying too fast. The dates and time.
I'm having a hard time understanding you. I can hear you. I just can't understand what you're saying very well.
Yeah, it's my connection is bad. I was saying you were saying the dates and times for the visitation. I need to repeat it. It was hard to hear you.
April 12 at 5 p.m. Do you have that?
Yes.
To April 14th at 5 p.m. You have that?
I do.
And then again, April 26th at 5 p.m.
April 6th or 26th? Yes.
26th.
I have that.
To April 20th at 5 p.m.
28th at 5 p.m.
With transfers to occur at the Hall of Justice in Cowlitz County.
Okay.
And you know where the Hall of Justice is, Ms. Brody?
And if he's, I do. If he's to leave, what happens with her? What if
he leaves?
I'm sorry, I didn't catch that.
If he takes her out of state, is it like what happened? What happens?
Well, he's not going to do that. He's been ordered not to do that. Ms. Height, did you have a question?
Yes, Your Honor. I have never had contact information that is reliable for Miss Brody. If I don't have a phone number currently or an address, if that could be included in my orders, I would appreciate that very much.
All right. Let me.
The last address I have was from a community house.
Can the clerk check in Odyssey to see if we have a current address for Miss Brody?
Yes, it is. But it's supposed to be confidential. But I mean, no, it's
Okay.
not.
I'm sure on the corner of all of her documents for file.
Okay.
On the confidential. Okay.
Oh my God.
All right. Well, while you may have requested that, Ms. Brody, you also included that information on every document you filed with the court. So because of that, it's not confidential.
I understand.
So, okay. Ms. Height, we will include that information in the order.
Thank you, Your Honor. I appreciate that.
If I may ask, Your Honor, should I wait for Miss Brody to get in contact with me, or is it okay to ask for a phone number here or while we're both present?
I'm sorry, say that again.
So I don't have any contact information for Miss Brody. I was wondering, should I wait for her to contact me, or would it be okay to ask for even a phone number while we're both present right now?
I mean, I see his phone number on the screen. I can get a hold of him.
Okay, Mr. Molina, is the number you have there on the screen the number she can reach you at?
Yes, Your Honor, the 352 number.
Okay.
Yeah.
I don't think there's any, let me just look at the restraining order. The restraining order, let's see, does not prohibit contact. It just prohibits assault, harass, stalk, or molest the protected person or child, or use force against the protected person or child. So the two of you can have contact, but and Miss Brody does have your number. So We'll see you back here again on May 1st at 9 o'clock in the morning.
Okay, Your Honor.
Thank you, Your
Yes,
Honor.
Your
Thank
Honor.
you.
All right, that'll come. Okay, so we're here on a few matters. Ms. Casiato has filed a motion asking the court to make a finding of adequate cause to change the parenting plan, and has also filed a motion for contempt for failure to pay child support. So this matter was continued from the 27th, and I don't see that there's any filings or anything from Mr. Miracle.
I had filed yesterday, Your Honor.
And what did you file yesterday?
I had filed a declaration responding to the contempt.
Has that, and Ms. Casciato, have you received that?
Yes, I have, Your Honor.
Unfortunately, I don't have it. It's a little unclear to me. Did the court already make a finding of adequate cause to move forward on the motion to essentially change the parenting plan?
No, Your Honor.
There's currently pending criminal charges of child abuse, and that the police are investigating still in Clark County. And last I heard from the prosecuting attorney is they are putting an victim's advocate on the case, but I don't know who or when.
Well, unfortunately, the whatever was filed yesterday has not made it into Odyssey, which is the way the court is able to access these pleadings. So I don't have the benefit of Mr. Miracle's response on the contempt issue. Without that, I don't feel like I can enter a ruling that takes into account both sides of things. I hate to put it over again, but I think that's where we are. I'm going to put it over 2 weeks to the 17th at 9 o'clock in the morning.
All right, thank you, Your Honor.
Thank you, Your Honor.
Yes, sir.
All right, I have in front of me, I've got Alyssa Smith filed a motion for adequate cause to amend the parenting plan. And then Jared Smith replied with a declaration filed on March 28th that essentially makes a similar request. Each of you is asking to change the parenting plan. But in different ways.
Your Honor, if I may, she purposely withheld the evidence that she filed with the courts. She did not give it to the sheriff's deputy to be served to me. I had to find out after the fact.
Okay, and that's not something that I'm going to address today. The proof of service filed on March 26th includes a summons, petition to change the parenting plan, family law calendar notice, declaration about public assistance, financial declaration of Alyssa Smith, a motion to adjust child support, and adequate cause decision worksheets, and a parenting plan. That's what the sheriff indicates they served. So if you're saying something was withheld from you you need to address that with a written motion if somehow that has a bearing on the case. I can't just address it orally here. So what's in front of the court is the motion for an adequate cause decision. Filed by Alyssa Smith on March 14th. And I guess in addressing that for both the parties, both of you have basically said the parenting plan isn't working. And the parenting plan was from 2022. And then I think in 2023, at some point in March of 2023, the court granted a temporary parenting plan, which is currently what's in effect. The March 29th order is what's the most current order. That's from 2023. You're both basically saying we need to change this. You're not agreed as to how it should be changed. So I'm going to make a finding of adequate cause that there is a basis to move forward on amending the parenting plan. The court will consider.
Your Honor, if I may.
No, you can't. The court's going to consider both of your positions in moving forward. So, and what I'm going to do is I am going to appoint a guardian ad litem, because we've had sort of constant, well, the parties entered what was close to a 50-50 plan back in 22. It seems like there's been sort of a constant issue since then. And we need to get to the bottom of this and get what's now a temporary parenting plan converted to a permanent parenting plan, and something that works for the best interest of the children. So I'm going to appoint our court investigator as the guardian ad litem. I will prepare an order to that effect. I'm not going to do anything today to change the current temporary plan.
May I ask which one?
The one that's currently in effect is the March of 2023 parenting plan.
So we've been doing Monday to Monday for the last 3 months. And there's documentation in there that's what we've been doing Monday to Monday, switching at schools. Versus halfway through the week. The kids seem to do better from Monday to Monday than half the week here, half the week there.
If the options are the March 2023 parenting plan or Monday to Monday on a temporary basis, are you okay with sticking with Monday to Monday?
Yeah, except for this week, I'm supposed to get them back today because he had them for half the spring break and I get them the other half. But other than that, Monday to Monday is fine.
Okay, we'll stick with Monday to Monday on a temporary basis until the matter is, until a final parenting plan is entered.
Okay.
Okay, and my understanding is Ms. Smith is going to get the kids back today. Is that right? Because of spring break?
Yes.
Yes.
Okay. Okay, so I'm going to appoint a guardian ad litem to address and I am making a finding of adequate cause. So both parties request to come up with a final workable parenting plan would be granted. And we'll move forward on that.
Okay.
All right, so that'll conclude the matter for today, and I will prepare the order appointing the guardian ad litem.
All right, thank you.
Okay. I think we're done.
That's all the cases I have.
All right. See some familiar names that I haven't seen for a while. Hope everybody's well. I'm going to end the session.
Okay, not hearing from anyone. Oh, Mr. Anagnosio, go ahead.
Well, Your Honor, number one, I'm going to object to the trial assignment. This matter is on for next week for dismissal for lack of jurisdiction. And in addition, discovery hasn't been completed, so I don't think this matter should be set for trial, given what's going on in the case currently.
So let me just call this and hold on. Let me just call this so we can get the parties all on board. I see Ms. Cotto there. Ms. Cotto, go ahead.
I would ask to go forward. This matter's been pending for 4 years and Mr. Anagnosto and his client have put up a lot of roadblocks. It is on for next week. Doesn't necessarily mean it's going to be granted. We need to get it on the calendar. We have a special master that's been appointed in this. We should, if I'm looking in July, we should have no problems with getting all of the discovery completed by July. The discovery's been outstanding for 6 months. It was due back in November, so I'd ask the court to set it.
Okay, let's see. I'm just looking here. Give me just a minute. And if we're setting, we're looking, the request is 2-day non-jury.
Correct.
Mr. Anagnosto, purely for setting purposes without waiving any objection to the setting itself, does that sound like a reasonable time frame for you?
What time frame? What are we talking about?
2-day non-jury trial.
Yes, it would be a 2-day trial.
Okay. Let's do this. I do think the parties have a right to get a trial date on the books. I don't think that prejudices anyone with motions moving forward because we probably are setting this out several months. So let's go ahead and get dates on the calendar. I absolutely understand, Mr. Anagnosto, your position as far as upcoming motions and that sort of thing. But let's start, Ms. Cotto, you said probably not until July.
Correct. That should give us plenty of time to get everything done. And I have an open calendar, pretty well open in July.
Okay. Let's start looking for a 2-day non-jury trial in July.
The week of July 1st.
I am out that week.
The week of July 8th.
I'm available.
But then I guess
And readiness.
readiness would be on the 2nd. So if you're going to be out, then maybe we shouldn't do that.
He could, counsel could, well, I don't know if he has anybody that can cover for him.
What if we, Ms. Anderson, do we have the week of July 15 and then we'll set readiness that prior week?
Yes, we do.
Okay, that will work for me.
Mr. Anagnosto, again, without waiving your objection, are you available on those dates?
I am, Your Honor.
Okay.
I don't think this will be ready for trial, but okay.
So then readiness would be on July 9th at 11:30.
Okay, thank you.
All right, thank you both.